É uma honra muito grande para nós. Vou passar agora a apresentação dos integrantes da mesa. A professora Fátima, que nos dá a honra da sua presença aqui hoje, também participando do nosso trabalho de tentar transmitir a vocês as lições, as ideias que vão ser trazidas pelo nosso palestrante, o Judge Jeremy Fogel. Ao lado da professora Fátima, temos o desembargador Beethoven. Ele está atualmente na condução, na direção do SEJUSC, no Centro Judiciário de Solução de Conflitos, do 2º grau do Tribunal de Justiça de São Paulo. E com um trabalho muito sério, empenhados estamos, eu sou membro integrante também da comissão, estamos empenhados efetivamente na implementação, na divulgação e no desenvolvimento dos meios alternativos de conflito dentro do Tribunal de Justiça de São Paulo. Uma honra muito grande para nós termos a professora Fátima e também o desembargador Beethoven entre nós. E o professor Fogel, o Judge Fogel, professor e Judge Fogel, que vem dos Estados Unidos, da Corte Distrital da Califórnia, do Distrito da Califórnia, e também diretor do Centro Judicial Federal dos Estados Unidos. Ele vem trazendo a sua experiência, a sua vivência, a sua visão, e vai nos falar um pouquinho sobre 2 paradigmas para solucionar casos cíveis. O que será que ele vai nos contar dentro de tudo aquilo que temos estudado sobre os meios alternativos de solução de conflito? Sem mais atrasos, chega o que o trânsito já causou, eu passo então a palavra ao Judge Fogel. Welcome.
I'm sorry, I need to give my talk in English. I understand some of what, some Portuguese, but I don't speak any, so I'll speak slowly, and then my remarks can be translated for those of you who don't speak English. So what I have is a presentation about mediation, but what I'd like to do before I start that is tell you how I got interested in mediation. When I was a lawyer, I represented people with mental health issues. One of the difficulties that my clients had was communicating with other people. And for me to be a good advocate for them, I had to learn how to listen very carefully. Sometimes what they said wasn't really what they didn't really reflect what they needed about something, and they would, because of their illnesses, they would be very emotional. I had to learn how to hear what they were really concerned about. They would say one thing, but there would be something underlying the problem that they were presenting. So they might be upset, and they might be imagining someone was chasing them, or some other type of delusion. And in fact, what they were saying was that they were upset about something that was actually a delusion. But what was actually going on was that there was a problem going on with their housing or with their medical care. And I had to learn to talk with them and listen to them to find out what the real problem was. After that, I became a judge. And what I discovered fairly early in my judicial career was that a lot of times people brought cases to court because of some other reasons, for something that was going on in their life that really didn't have all that much to do with what they were saying in the court case. And where I really learned this the most strongly was when I was a family court judge, which I did for 4 years. The law was actually very clear in California that the property of the parties in the marital dispute had to be divided equally. People would still fight about the property, and they would get very, very focused on who was going to get a particular piece of furniture. And we also, in our family law, have a concept called no fault, which means that in order to get a divorce, you do not have to prove whose fault it was that the relationship is ending. All of those issues about what had happened in the relationship between the parties were irrelevant. So what I came to realize was that most of the time, the reason that people were fighting over the piece of furniture was didn't have anything to do with the furniture. Instead, it was a way that they could channel the feelings that they had about each other, and this led me to become a student of mediation. Because we know that in mediation, the interests of the parties, the real interests of the parties, often are different than the legal positions that they take. So now I will go to my prepared talk. The first slide describes what I have called the adversarial paradigm, and that is the way people relate to each other in a formal litigation environment. And this is true whether you're in a common law or a civil law system, that in civil cases, the parties are taking positions opposite each other. And the role of lawyers is to represent the legal positions that have been taken by their client. And the goal is to win the case on behalf of your client, which means in a adversarial system that the other client loses. This is what I mean by a zero sum in the slide, that there is a winner and a loser. And there's also the behavior of the advocate is designed to maximize their position and minimize the other person's position. And the parties, or the lawyer's concept of what can be achieved is limited by the legal results that are possible. Mediation is fundamentally different. Its purpose is not to have winners and losers, but instead it is to solve problems. It works best when the advocates and the parties collaborate and cooperate to try to reach a solution. It works best when you understand what the real concerns and interests of the parties are, which may or may not be reflected by their legal positions. And to go back to my family court example, if I were mediating a dispute about who would get the piece of furniture, I might start that mediation by saying, why do you care about this so much? And as a mediator, it wouldn't matter to me whether the answer was legally relevant or not. So if they said, let's say it's the wife talking, and she says, he knows that I want that piece of furniture, and that's why he won't let me have it. And through that piece of information, I become aware that there is a lot of emotional sense of power imbalance between the two parties in the case. And so if I'm trying to mediate the case, that is the problem I'm trying to solve, and not who has a better legal claim to the piece of furniture. So this approach, what you're trying to do is integrate the interests of the parties and try to reach a resolution that gives both parties as much as possible. It's sometimes misunderstood as being a situation where you make both parties equally unhappy. That's a forced compromise where you say, well, I'm just going to divide the furniture down the middle and you're both going to have to live with it. That is not mediation. That is forced compromise. And the goal of a true mediator is to make both parties as satisfied with the outcome as possible, and to look for creative ways to do that, even if they are solutions that wouldn't be possible if the case was litigated. The role of advocates in mediation is different as well, because their role is to make sure that their clients' interests get fully explored, but it's not necessarily to take anything away from the other party. it's just simply to make sure that everything your own client cares about is shared with the other side and with the mediator so that it can be integrated into the solution. So we know that when cases go to court, that both the lawyers and the parties often have unstated interests. And I've already given you one example in my family law case, and then this slide lists some others. And then these are some of the ones that lawyers sometimes have. I was talking with some judges last night, some Brazilian judges, and they were saying that one of the difficulties from their perspective in making the justice system more efficient is that lawyers have learned to work within the current system and are fearful that they would lose income if the system changed. And this is an international phenomenon. I helped start a mediation center in India, and shortly after the mediation center opened, some of the lawyers whose cases were going to be shortened as a result of mediation went on strike. And it's a problem in the U.S. as well, because litigation is very expensive, and a lot of times lawyers feel under pressure to bill a certain number of hours to their clients. Mediation is focused on the needs of the parties and not the needs of the attorneys. So for lawyers, it takes a while to get used to the idea that it may actually be better for them as well as for the clients to use this process. However, our experience is that lawyers who become successful in using mediation actually have a lot of clients, because the clients feel rightly that the lawyers are going to pursue the case in a way that's consistent with their interests. So in most systems, lawyers are expected to be zealous advocates for their clients. And what that is often understood to mean is that the lawyer should do everything possible that isn't illegal or unethical to help the client win the case. However, in a mediation paradigm, the lawyer still can be a zealous advocate for the client. But the focus is quite different. The focus is on making sure that the client is heard and that the client's interests are addressed rather than on defeating the other side. And if those interests can be heard and addressed by an agreement with the other side outside of court, that's absolutely fine. To do this well, however, the advocate has to become a very good listener and a very good problem solver. And these skills are not always taught in law schools or encouraged by legal education. So this chart gives you a sense of the different types of dispute resolution, and this is reflective of what we have in the U.S., but it's not unsimilar to what exists in other countries as well. And what I'm trying to illustrate here is that there is a spectrum of ways that people resolve their differences. At the top you see negotiation, which simply means that people work out their differences between themselves voluntarily without anyone else being involved. And actually, human beings resolve the vast majority of their disagreements in this way. At the other end of the spectrum are the types of processes where the right to resolve the dispute is totally given up to a third party. And so you see there a trial by a court or arbitration where an arbitrator makes a final decision. The important point, though, is that at the bottom of the chart are processes where the parties have no control over the decision. And at the top of the chart, where you have negotiation, the parties are in complete control of what the outcome is. And you'll see that the next process below negotiation is a form of mediation called facilitative mediation. And sometimes this kind of mediation is described as facilitated negotiation. The parties still are the ones who are going to decide how the case is going to be resolved. And the role of the mediator, the third party, is to help them get to a result that they both can agree to. But notice that the mediator makes no decisions in this process. The mediator does not decide anything. The mediator simply helps the parties talk to each other. And then the next process down is something called evaluative mediation. And this is where the mediator will sometimes give an opinion to the parties about what the mediator thinks would be a good result in the case. But still, the ultimate decision of what to do is up to the parties. Once you leave the type of process where the parties are deciding, then technically it's no longer mediation. So that's why the example of forcing people to settle or not listening to them or developing their interests and just telling them what to do, it might settle a case, but it isn't mediation. One of the things that judges and lawyers need to think about is when a facilitative process like mediation is appropriate. Because there certainly are cases where it's not an appropriate process. Typically, the cases that are most open to mediation are ones where the parties have some type of historic or ongoing relationship. It's not an accident that mediation developed in family courts, in places where people were sort of neighbors or they were disputing title to a piece of property, and they had pre-existing relationships and they were likely to have to live together going forward. But the relationships I'm talking about could include business relationships. They could include partnerships. They could even include competitors in business where parties were going to have regular contact with each other. And the reason why a relationship is a factor that indicates that mediation would be good is that people have feelings about the relationship and how they want the relationship to be, and that is one of the interests that needs to be explored. Another reason that mediation is popular is that it's confidential. People can discuss matters and resolve them without there being a public record of what was discussed. As I mentioned earlier, mediation also offers the possibility of resolving the case in a way that wouldn't be possible if you had to get a judgment from a court. Usually mediation is less expensive than going to court, and it is usually faster. It's certain because if the parties reach a mediation agreement, there aren't any appeals, and there usually isn't as much of a problem with enforcement of the agreement. And I think one of the most important things, and it sometimes gets overlooked, is that mediation gives the parties a chance to speak directly about why they're in the dispute. In court, parties usually speak through their lawyers, and it's actually pretty well established that one of the reasons people feel dissatisfied with the legal system is that they don't get a chance to really say what they want to say in the way that they want to say it. Sometimes, as I said, there are cases that aren't appropriate, and just to give some examples, if people have two entirely different versions of the facts, and somebody's lying or somebody is mistaken as to what happened, sometimes you need a third party to decide what the truth is. Sometimes there is an issue of law that has to be decided by the court and cannot be resolved without going to court. Sometimes there are public policy reasons for using the public court process. For instance, if you had a corruption case, I know that's in the news here, if you mediated that case, you might resolve the case, but there would be a problem of transparency. The public would wonder what happened in the mediation. Or we've had a problem in our courts with defective products, say a car that was manufactured defectively, and if you settle that case through a confidential mediation, then the rest of the public doesn't hear about the product defect. And sometimes you just have people who won't participate in good faith. So when you have those types of factors, you may not want to use mediation to try to resolve the case. And then one last thing regarding when to use mediation, timing is important. The parties need to have a fairly good understanding of what their dispute involves. So depending on what kind of case it is, the parties may need to do some investigation before they can really evaluate what they want to do. There are other kinds of cases, however, where the parties know everything they need to know even before the case is filed. If it's a domestic case and the parties are well aware of their problems with each other and they're well aware of what property they have and how many children they have and so on, they can usually go to mediation in this sense without the need for additional investigation. Another factor, however, is whether the parties are motivated to try to resolve the case. And that changes over time. Sometimes when people first file a lawsuit, they are feeling very angry or very self-righteous, and they absolutely want to go to court and win the case. And then after they see what the reality of the court system is for a few months, at that point they're more interested in resolving the case. So it's possible to try to resolve a case too early. Sometimes there are legal proceedings that have to take place before the parties can decide whether they want to resolve the case or not. And a simple example of that is, let's say there's a question of whether there's insurance coverage or not. The defendant needs to know, and the plaintiff needs to know, whether there's insurance before they can decide what type of financial settlement they want to make. And then finally, the timing depends on what type of process you want to use. And if it's an evaluative type of process, usually it makes sense to do it later after the parties have had a chance to investigate. I have to say, though, that I think having facilitative mediation as an option in a court system greatly improves the system. It gives the parties confidence that they can at least have a chance to resolve the dispute on terms that they're satisfied with. It reduces delay and uncertainty enormously, particularly in systems where there's a large backlog of cases. And I think the most important thing is that the parties are satisfied with the process. And I will close my formal presentation by telling you some statistics from my days as a family court judge in California. There was a survey done of people who had contested cases decided by a judge in the family courts. And they were asked whether they were satisfied with the system. And the great majority of the people who responded who had contested cases said that they were very dissatisfied with the system. At the same time, there was a survey done who had participated in the mediation program that was offered by the family courts. And the people who had resolved their cases through mediation, a majority, well over 60%, said that they were satisfied with the process. And remember, these are contested family law cases which probably have the highest level of emotion of any type of case I can think of. Okay, so now I would love to discuss this with my fellow panelists and take your questions.
Eu acredito que nós podemos abrir agora a oportunidade para perguntas que os senhores queiram fazer. Quem fizer as perguntas, por favor, faça. Eu prometo que traduzo direitinho para o Judge Fogel. Enquanto os senhores vão pensando numa primeira pergunta, I would like to make a first one. Do you allow me?
Sure.
Nós temos aqui no Brasil a situação de juízes que usam a mediação em casos em que eles poderão vir a atuar como julgadores no caso da mediação não dar certo. A minha pergunta, então, para o Judge Fogel é, de acordo com o que ele falou sobre o sigilo, se ele entende que isso é uma forma aconselhável de atuar ou não.
That's a great question. I think it's very difficult to do that. I don't think it's impossible, but I think the difficulty is that for mediation to work the way that it should, the parties have to be very self-disclosing to the judge. And it's very difficult for most judges to forget what they've heard in the mediation or not in some way be influenced by it. It's also, I think, harder for parties to be very candid when they know that the same person will be deciding their case. Now, having said all of that, I have done this a few times. And what I've done is, in the mediation, I have never, ever suggested what I thought the outcome should be. I've simply tried to get the parties to talk to each other more effectively. Another factor is that in civil trials in the U.S., we have juries. So if the case doesn't resolve through the mediation, a jury will be finding the facts and not me. However, I still have found it the few times that I've done it. Well, the times that I did it because the parties asked me to. I never encouraged a party to do it or told a party to do it in a case where I knew I was going to be the trial judge. And in the cases where they asked me to do it, I made sure that we had a conversation, that they understood that I would do my best not to allow what I learned in the mediation to affect any decision I made, but I could not promise them that I wouldn't be unconsciously affected. There was one case where I conducted a mediation. It was in one of my own cases, and something happened during the mediation where I concluded that one of the parties simply had an unreasonable view of the case. And so I made a decision that I would share that perspective with this party, and at the same time I asked that another judge conduct the trial. And the party did not accept my advice, and the party went to trial before another judge, and he lost.
Advogado, ele pode ser ao mesmo tempo advogado e mediador num caso?
All right, so let me see if I understand the question. If you are representing a client, I think it's quite possible to represent the same client in a mediation and as an advocate in trial. You just have to use different skills. I also think that lawyers can be excellent mediators for other people in other cases. In other words, the mediator doesn't have to be a judge. A lawyer can be a mediator in cases involving other parties. And in fact, some of the best mediators I know also are lawyers. And they have told me they've told me that the lawyers have told me that they believe that they are better lawyers as a result of having learned to be mediators because they listen better, they understand people better.
No nosso setor de mediação não há chefes. Somos todos colaboradores. A Cris e eu trabalhamos lá, por delegação do nosso querido presidente. Eu vou perguntar para ele, para o nosso querido palestrante, uma coisa, mas antes de perguntar, eu vou falar para os senhores. Está uma lei na Assembleia. Vai traduzindo. Vai traduzindo. Existe uma lei na Assembleia que o mediador que trabalha conosco lá vai ser remunerado. Então eu vou perguntar para ele, no my poor English, have a special chamber of conciliation in your court?
So it varies depending on where you are. My home court in Northern California has a full-time staff of mediators, and we also have a lot of volunteer mediators who work with our staff mediators. They are lawyers, and we provide training for them. And then they work on cases that are assigned to them by the judges. And the first 4 hours of service that they provide are free, and then after that, the parties can agree to pay them. Other courts in the U.S. have similar systems, and there are places where judges will do mediation as well. I actually think that a system like the one our court has is a very good system because you have professional mediators at the center of the system, and then they can train the additional mediators, and they also are a very good resource for the judges.
Okay, so I like to ask you because you said about communication skills, and it seems to me that you have to develop lots of new skills, maybe like how to listen, how to communicate, even how to understand that a party is lying at that moment. And I understand that you have to develop a sort of quite a bit of skills for that. Are there good ways to train, to educate those judges and those mediators?
Yes. So there are mediation programs that are offered by a number of our universities. And most of them involve a week or two of intensive training in the skills you were just describing. Our court requires all of our mediators to have had that type of training. When they first join our mediation program, they sit with an experienced mediator as an apprentice for a certain number of cases. And I believe actually that right now, some representatives of one of the programs, it's the one at Pepperdine in California, are actually in Sao Paulo. I don't know where they are,
Yes,
but
they are coming.
They're coming, right?
Yes.
And they do one of the very good programs. So the other thing, just it's a little short story, but in my law school class, I have tried to make this exact point to the students that this is actually very different from what they already know how to do. So I ask them to break into groups of two and to listen to each other without interruption for 5 minutes. And I've done this for many, many years, and they can never do it. Because the way we talk to each other, we talk and we interrupt and we say, oh, that happened to me, and that kind of thing. And if a client can tell that you really are paying attention only to them, most of the time they will tell you all sorts of things. And the same realization has been made in medical schools in the U.S. Because when doctors are talking to a patient and they're trying to find out why the patient has come to the doctor's office, a lot of times, unless the doctor's listening very well, the patient won't really tell them. But if the doctor's listening carefully, the patient will reveal a lot of additional information that's very helpful in making the diagnosis.
I would like to know, what do you think about the first audience, conciliation, okay, about conciliation?
I talked about timing. When I first started as a family court judge, that's what I did. I did the first hearing in about 25 or 30 cases every day.
Wow.
Usually, when people came in for their first hearing, they were either angry or scared or depressed, or they were in denial that the divorce was taking place. But usually they were feeling something very strong one way or another. So what I did was two things. I would start out every day by saying to the group of people who were there, I understand that this is an extremely difficult moment in your life, and you're probably feeling some very, very powerful emotions right now. And you're probably hoping that the court system will somehow give you vindication for the way you feel. And while that's a very understandable feeling, it's not a realistic one. This is very important at every step of the process that you think about whether there's a way to resolve the differences that are dividing you. And that if you decide, if you don't do that, you'll end up being sorry later, because you'll spend a lot of money and you'll go through a lot of emotional pain. So the strategy was to acknowledge the way people were feeling first, to make sure that they felt understood, and then sort of to talk realistically about what happens when cases in family court don't get resolved. But if I had just said, look, I'm really busy, I don't have any time, you need to settle your case right now, they would have had a very different response. So I think the most important thing that a judge can do at a first hearing is to be human and to be compassionate. I think, unfortunately, in some family courts, and I can really only speak about in the U.S., some judges really don't want to be there. They would rather be hearing other kinds of cases, and they communicate that to the parties, that they don't really want to be there. And that just makes things worse.
Talvez a pergunta seja um pouquinho longa, e se a senhora quiser ir traduzindo. Primeiramente, gostaria de afirmar que eu fiz o curso aqui na ESA, de Conciliação e Mediação, e hoje, efetivamente, eu me considero um advogado talvez mais completo. Porém, nem sempre o cliente vê isso como um benefício. Eu li numa pesquisa que o Brasil é um dos países de maior litigiosidade dentre 50 ou 60 países. Acho que o TJ até não gosta de ouvir isso, mas muita gente diz que a mediação e a conciliação ela foi feita aqui basicamente para desafogar o poder judiciário, né? Ocorre que em 95, acho que fizemos a lei 9.099, né, Juizado Especial Civil, também acho que tinha essa característica, né, de além de cuidar da possibilidade de ser uma justiça gratuita, ela também deveria ser mais rápida. Hoje, o que a gente tem, efetivamente, é que os juizados talvez estejam piores do que a justiça, vamos dizer assim, comum, né? Em razão dessa litigiosidade, ele vê a possibilidade, pelo menos, obviamente, nos Estados Unidos, dessa solução de conflitos entrar na mesma baila que entrou a 9.099, ou seja, ela pode começar bem, mas depois enfrentar também uma demora excessiva. Basicamente seria isso. Obrigado.
So do you have an hour? No, that not only is a very good question, but it really states something that I worry about. The reason I spent so much time at the beginning talking about listening and really understanding what motivates parties is that is the absolute heart of mediation when it's done properly. The parties have an opportunity to really say what's on their mind and to try to work out a solution that addresses what they care about. And that's why I said it's really a different paradigm than the one that we have in litigation. The problem is that when you have it in a court system that has too many cases, there is a very strong temptation to use it simply as a way of eliminating backlog, without regard to the quality of the process. So you end up with mediators being say, well, how many cases did you resolve? Instead of being asked, how well did you resolve those cases, and are the clients satisfied with the resolutions? And you end up having a process which is more focused on getting an answer than on getting the right answer or getting a good answer. So there have been some academic criticism, which I share, that if you don't pay attention to quality, what you end up is, the phrase that's used in the U.S. is litigation light. So the parties get the same disruption of their life that they get in litigation, but they don't get any of the procedural rights that they get in litigation. I do worry that there is pressure for ADR programs to be more focused on numbers than on really doing things differently, which is why I think really good, strong training programs are very important. But I do think you raise a legitimate question.
She is asking how many sessions, how many hearings could you have in the United States
in mediation?
until you get to the outcome?
In mediation, okay. Well, there's no limit. Most cases have one or two, but there's no, there's nothing that prevents parties from having more if they want to.
And would it be not advisable to use many of them to prejudice?
I think it depends entirely on what kind of case it is. So some cases are fairly simple, and one mediation session usually is enough for the people to explore the possibilities of settlement. Some cases are very complicated and you need more time. And sometimes you need more time because as you get into the mediation, you realize that you need more information, or sometimes you need different people to be in the room. And I'll try to give this example as briefly as I can. So I was mediating a patent case, and it became apparent that the two parties to the case were going to be able to work out some type of business arrangement that would allow them to settle the case. But they needed time to write up the documents because there was a lot of licensing and other contractual work that they needed to do to make this business solution work out, and it was going to take them time to do that. And there were disagreements that were likely to come up in the drafting of the documents that would still need to be mediated. However, the main problem was that there was a third party that wasn't actually part of the case that would have to agree to the settlement that one of the other parties was making, because it affected the relationship between that party and the third party. So I had to get a representative of the third party to join the mediation and help us work out a resolution that worked for everybody. So I actually had 5 sessions in that meeting, and the case resolved, and it resolved several other cases that weren't before me. And had the case proceeded to trial, it would have cost both parties several $1 million.
Wow.
That you have been researching about patent law?
Patent law. Mm-hmm.
Yes, because it's interesting, the point is that how a mediator can be an expert and know everything about that, and he has to learn, but up to what point?
That's a good question. So this is an interesting question among people who train mediators. Some people believe that if you train people to be experts on the process of mediation, that it is less important for them to know about the subject matter, because they're not going to be giving an opinion about the case. They're there to help people resolve differences. So in that sense, it doesn't matter what the subject matter is. In fact, though, I think that's a little too simple, because you have to be able to speak the language that the people are speaking. I mean, I'm a good mediator, but I could not mediate a case in Brazil with 2 people who only spoke Portuguese. And patent law in particular has a language that even if you're fluent in the language that's being spoken, if you don't understand the technical terms, it's very difficult to understand some of the nuances that people are trying to communicate to you. I was fortunate because I have no technical background at all, but my court is in an area where we get patent cases constantly. It's in Silicon Valley, so I get patent cases involving computers every day.
Oh.
And so I learned through the process of doing cases, I learned a lot about patent law and the subject matter. So it's just easier to mediate patent cases once I had that experience, because I was comfortable with the terminology and with the particular culture of those kinds of cases.
Primeiramente, eu fiquei feliz por ratificar o curso que eu fiz. O que ele falou não foi grego. Mas a minha pergunta é a seguinte: existe algum programa nos Estados Unidos de divulgação da mediação perante a população? Porque o que eu observei no estágio que eu fiz é que a posição dos advogados impedia muitas vezes o acordo. E a parte não estava nem sabendo do que se tratava. Se existir esse programa nos Estados Unidos, que não existe no Brasil, não facilita muito a mediação, porque o desconhecimento é a arma de muitos para subjugar os outros, né? Existe esse tipo de programa de divulgação da mediação nos Estados Unidos?
Well, so there's not an official organization. The American Bar Association, which is the organization the largest organization of lawyers in the U.S., has an entire section that's devoted to ADR. And they deal with this issue a lot. How do you get the public to be more aware of the kinds of programs that are available? I also think that that judges who understand the principles can be very good educators in this area, because they are in positions of authority and they can explain to people who come into their courts how mediation is different. And we've had the Federal Judicial Center, where I work now, has had a mediation skills program for judges for at least the last 15 years. And some of those judges have been very active in trying to educate the public. I would say, though, that I'm not satisfied with the degree of understanding of these options in the U.S. And it's largely because of the question that was asked earlier. I think the lawyers are pulling it back toward adversarial process without even realizing that they're doing it, because people do what they're comfortable with and familiar with. And that's why I encourage lawyers to take mediation training programs, because once they get the experience of being a mediator, they really, it makes them better lawyers, in my opinion.
Eu queria agradecer imensamente a atenção de vocês. Daqui eu pude captar cada olhinho, cada vibração de vocês. Foi muito gostoso pegar isto. Eu espero que essa palestra tenha trazido muita colaboração, muito material positivo para vocês no dia a dia, no exercício da profissão, como estudiosos, como acadêmicos também. Queria agradecer imensamente a preciosa colaboração e presença e figura dos ensinamentos do Judge Fogel aqui conosco. Foi realmente um privilégio enorme tê-lo aqui. Judge Fogel, we want to thank you very much. It was for us a very special privilege to have you here with your knowledge, with your teachings, and we are certainly no more the same after hearing you, for sure. Agradecer também. Agradecer também a presença do meu querido colega, o desembargador Beethoven, que é uma pessoa especial, acreditem, nesse mundo de mediação, acho que vocês já ouviram falar dele, e também a professora Fátima, tão sorridente, e da qual também sou uma grande admiradora.